Tonight, we begin with a courtroom development that legal observers had anticipated, dismissed, and feared in equal measure. A revelation that unfolded not over weeks of testimony, but in minutes. Minutes that halted a high-profile trial mid-session. Minutes that sent prosecutors scrambling to reassess their entire case. Minutes that left a defendant's fate hanging by a thread. What happened in that federal courtroom today crossed a line that the presiding judge had hoped would hold. And when that line broke, Judge Patricia Morrison did not hesitate. She responded with precision, authority, and unprecedented speed. For 3 weeks now, there had been whispers, not from official court filings, not from formal motions, just whispers, that the defense was preparing something explosive. The defense team has been aggressive, yes, but they have been calculated in their aggression. Their moves have followed a certain rhythm, a cadence, almost a playbook. But what set off alarm bells in the prosecution's war room this morning was that the rhythm went silent. Trial watchers who monitor courtroom dynamics know the indicators: the pretrial motions, the witness prep sessions, the sidebar conferences, the sudden absence of objections. All of that went quiet. And whenever a defense team goes quiet, it means something is about to get loud. Early this afternoon, court observers detected what they described as unusual activity in the witness staging area, including last-minute additions to the defense witness list that had not been filed in over 2 weeks. These are the kinds of strategic moves that defense attorneys only deploy when they are signaling something very specific: new evidence, witness impeachment, or case-ending testimony. Legal analysts didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that the defense was changing strategy. And when experienced trial attorneys shift strategy without explanation, even by subtle measures, opposing counsel pays attention. The reaction issued by Judge Morrison this afternoon was not normal. It was not routine. It was not symbolic. It was urgent. Court insiders after emergency chambers meetings described the defense's move as unprecedented, carefully orchestrated, and perhaps most importantly, admissible despite vigorous prosecution objections. But courtroom drama only works if the target hesitates. Judge Morrison did not. In fact, her response today was among the swiftest we've seen in federal proceedings. Here's what we know. Within minutes of the witness taking the stand, Judge Morrison called for an immediate recess. These weren't the standard 15-minute breaks. These were emergency chambers conferences, the kind that judges only convene when they are preparing to fundamentally alter trial proceedings. Tonight, court sources confirmed that Judge Morrison launched emergency procedural reviews on multiple evidentiary claims, including testimony that had recently been challenged for chain-of-custody issues that analysts believe was designed to undermine the prosecution's timeline. The judge acted before prosecutors could effectively object. She reviewed the witness credentials. She examined the documented evidence. She questioned the authentication protocols that were likely preparing to support the bombshell testimony. In other words, Judge Morrison targeted procedural integrity, the foundation that would have made it operational. This is what made the prosecution's objection so urgent. The defense's move wasn't just theatrical. It was substantive. It represented the kind of evidence that could collapse the entire case if left unchallenged. And Judge Morrison, understanding that fully, responded with caution. Not recklessly, not impulsively, but judiciously. And here's where the story becomes even more compelling. Legal experts now believe that the defense's latest move was designed to test the strength of the prosecution's narrative after weeks of increasingly shaky witness testimony. The defense wanted to see whether prosecutors would fold under pressure. But instead, the opposite happened. The prosecution didn't retreat into damage control. They filed emergency motions that were so comprehensive, so meticulously documented, that even the defense team paused. You don't get a federal judge's attention easily. But today, both sides did. Trial analysts speaking with media under anonymity described the defense's gambit as strategic provocation, a way to expose weaknesses in the government's case. But prosecutors proved today that they remain both prepared and adaptable. Their objections were not only substantive, they were documented so precisely that they included time-stamped communications contradicting the witness account. As reports continued coming in throughout the afternoon, we learned more about the scale of the judge's intervention. Court security carried out witness sequestration protocols, forcing additional defense witnesses to wait outside. The judge's clerk targeted exhibit authentication procedures that had been questioned in the last 72 hours. Court reporters operating under seal reportedly documented sidebar conversations used by both sides to negotiate next steps. This wasn't just standard trial management. This wasn't just routine procedure. This was crisis intervention. This was damage control. And damage control is the one thing this trial has struggled to maintain since jury selection. For every tactical advantage the prosecution has claimed, the defense has countered with something that muddies the timeline. What makes this moment so critical and so volatile is that this development happened at a time when the lead prosecutor is under intense scrutiny. Defense advocates want acquittal. Victims' families want conviction. Legal reformers want precedent. Media observers want drama. The prosecutor is balancing these demands while managing a case that's already exceeded its projected timeline. And when prosecutors in that position make sudden procedural moves, they're not doing it from strength. They're doing it from pressure. They're doing it from vulnerability. The defense understands this dynamic perfectly, which is why they chose this exact moment to deploy their most devastating witness. As the evening goes on, we expect more details to emerge about what exactly the defense hoped to achieve with this stunning courtroom maneuver. But what we do know is that Judge Morrison's intervention was timely. It preserved the integrity of the proceedings. It gave both sides time to regroup. And it demonstrated that federal judges will not tolerate trial by ambush, regardless of which side attempts it. What happens next will depend on what the defense does in the next 48 hours. If they can authenticate their evidence, this moment will be remembered as the turning point that saved their client. If they cannot, prosecutors have already shown they are ready to capitalize. This story is far from over. But tonight, one thing is clear. The trial everyone thought was predictable has become anything but. And the witness who took the stand today may have just changed everything.